Today, we're diving into a really tough question. How do we protect children without completely trampling on the rights of their parents? We're going to explore this through one single, incredibly complex case out of North Carolina that, honestly, shows the cracks in the entire child welfare system. This right here. This is the question at the heart of so many battles in courtrooms and social services offices. The case we're about to walk through, it forces all of us to look at what happens when that line between protecting a child and preserving a family gets dangerously blurry. So let's get into the story. In the court records, it's just called In Re MB. And like a lot of these cases, it all kicked off with a single report to the Department of Social Services. And wow, did things escalate fast. An initial report in late September just spiraled. After the mother, Kelly O'Neill, pulled out of a safety plan, DSS filed a formal court petition the very next day. And just 24 hours after that, the child, Mara, was placed with her grandmother. All of a sudden, this grandmother has the immense duty of providing for Mara's day-to-day care and safety. Now, one of the first tools DSS pulled out of their toolbox was this: a temporary parental safety agreement. It's a really powerful piece of paper that, right off the bat, restricted the mother to supervised visits only. And all of this happened before a judge had even heard a single argument in the case. So what even are these agreements? Well, you can think of them as a kind of emergency measure. They let DSS place a child with another caregiver fast if they think there's a safety risk. But, and this is a big but, they're super controversial because they can separate a family without a judge signing off first, which raises some pretty serious questions about due process and legal rights. By February, the court had made its formal ruling. And I want you to focus on these two words here: neglected, which basically means the child wasn't getting proper care, and dependent, meaning the parents just couldn't provide that care without help from DSS. These legal terms, they were the key that opened the door for everything that was about to happen. Now, you might think a court ruling would calm things down, but nope. Things actually got even more intense. The court's orders got more and more severe, and each one was a direct reaction to what the mother was doing. The whole situation just spiraled. I mean, it started with 1-hour supervised visits a week. Then a visit got cut short because the mother was recording it. After that, threatening texts and social media posts targeting DSS staff started appearing. The court's response, it was swift and it was severe. A complete and total ban on all contact, indefinitely. Now, from the court's point of view, its actions were totally logical. A legal analysis of the case even backed them up, calling the decisions direct and proportional. The argument was, the mother's behavior left them with no other choice. But there's another side to this coin. The mother's advocates argue that this no-contract order was basically a de facto termination of her parental rights. They're saying the court effectively ended her legal relationship with her child without going through the very strict, very protected legal process that's required for something that drastic. And you can really see how this played out when you look at the two parents. Their paths just went in completely opposite directions. The father, Michael Bridges, he did everything DSS asked. He complied with his case plan, and the court saw him as a qualified guardian, rewarding him with a trial home placement. The mother, on the other hand, well, she was seen as non-compliant, and her contact was just completely severed. And that brings us to the mother's side of the story, which, as you can imagine, paints a very different picture. This is a story of a system that she claims just ran right over her fundamental civil rights. So, what's the first legal challenge they've raised? Well, it's a big one. A violation of one of our most basic rights: free speech. The court basically hit Ms. O'Neill with a gag order, telling her she couldn't post about her case on social media. Her lawyers argue this is an unconstitutional prior restraint, which is just a fancy legal term for censorship. They say the court had no business doing that because her posts weren't directly connected to why her child was taken in the first place. The second legal challenge is just as serious. This one claims a violation of the 14th Amendment, which is supposed to guarantee everyone a fair legal process. And we're back to that no-contact order. The argument here is that parents have a fundamental constitutional right to their kids. And what the court did with that ban was, again, effectively terminate the mother's parental rights. The problem? They allegedly did it without the clear, cogent, and convincing proof, which is a really, really high legal bar that's required before you can permanently separate a parent and child. And then there's the third major challenge, which is an allegation of discrimination under the Americans with Disabilities Act, the ADA. So the argument here is that Miss O'Neill's mental health condition means she's part of a protected class under the ADA. The claim is that DSS didn't provide support that was actually tailored to her needs.
Instead of looking at her real parenting skills, the system just saw her diagnosis, assumed she was incapable, and robbed her of any real, fair chance to get her child back.
It's really tempting to look at this and just see one tragic story. But the truth is, the problems in this case are really just symptoms of a much bigger illness that's affecting North Carolina's entire child welfare system. Get this. North Carolina's child welfare system is the least state-funded in the entire nation. That creates this horrible cascade of problems. You've got a revolving door of overworked staff, services that are totally different from one county to the next, and this ancient paper-based data system. These aren't just statistics, they're the recipe for a crisis. But there is some hope on the horizon. The system is trying to fight back with some major reforms. There's new legislation for better state oversight, a huge tech upgrade to finally unify all their data, and an $80 million investment in kids' mental health. So change is trying to happen. And that leaves us with the million-dollar question, right? As states like North Carolina try to fix these broken systems, how can they build one that actually protects kids without destroying families in the process? It's a massive challenge, and it's one that really cuts to the core of who we are as a society.